Hello.
Hi.
Hi.
Good evening.
Good evening. Give it a minute and then we should start.
Yes. Good evening, sir.
Good evening, Jamshed sir.
Good evening. Good evening.
So I think we'll wait for a minute and then.
Should we start? Jamshed sir?
Yeah, go ahead.
Okay. Hello all. I hope everyone is healthy and safe. Welcome to the first session of ILA Dialogues, where our members share their experiences about law, the important work they've been doing, and important work and advisory that they've been doing from their respective regions. Today we have with us Advocate Rajdeep Lahiri. His team, RL Advocates, Attorney and Advisors, which is a young, dynamic team of advocates, company secretaries, chartered accountants, and debt syndicators from across the cities of India, which include Mumbai, Kolkata, and New Delhi. I think we have some of his team members here and newly joined interns, if I'm not wrong. Some of Rajdeep and Team RL's varied areas of practice consist of financial and white-collar crimes, admiralty and maritime law, banking and finance, media entertainment, IPR, consumer laws, labor laws, etc. Thank you for being the first speaker, and we look forward to hearing about your experience on digital and physical hearings during the COVID times. You're on mute.
Sorry. Thank you, Sudisha. Thank you, Jamshed sir. It's a privilege, pleasure to speak on something which, in all practical sense, will be needed for people who are experiencing this. For the reason that we are all experiencing this for the first time, so we are on equal footing over here. And number two, for people who are intending to rejoin practice, in the sense that they want to come on board and start the digital hearings through video conferencing, which is happening everywhere. Well, they say it's happening everywhere, but that's not the case. So digital hearings during this COVID-19, of course, at the very preface, I would want to say that a lot has been said and heard. There are a lot of sessions that has happened, which has very lucidly explained as to the entire histrionics of the entire process of digitization in India, especially in the litigation front, and those are all documented information that are available everywhere. So we've traversed various eras where systematically the introduction of technology has been made unknowingly, and we've seen the time where there used to be the assignment of judges, or the case lists were done in physical format only, and there used to be clerks and interns and juniors running after from court to court, trying to underline which matter is listed where. Of course, our senior members will be able to explain much better on that front. I have seen that for a fact because I come from a family of advocates, and I've seen that even I was made to do that once. And so we've come from that era suddenly into an era where there were computers, and of course there were the pager systems. Then we suddenly come into an era where we are finding the case status at our fingertips, at the touch of a few buttons on our laptop, on our computer system, and we are seeing the entire Roznama. We are seeing the orders passed. We are seeing the last date, next date. We are seeing the details of the cases that are being filed. And to a very great extent and a significant extent, technology. So first we need to understand what is the purpose of technology. The purpose of technology is to aid and assist the normal working of a human being in any sector. I would go ahead and say that technology, the influx of technology has been greater, has had a greater impact in the other sectors. As far as the influx of technology into litigation sector, from my point of view, has been very slow, primarily to the fact that the adaptability there, we lawyers have always faced a very great adaptability issue. We need to understand that litigation in India comprises of litigation at very lower levels. So we have the trial courts, we've got commissions, we've got courts at far off places. I primarily come from a place where it is not a very technology friendly region of the country. I come from West Bengal, and apart from the fact that there are brilliant advocates, there are brilliant judges who are at the bar of the Calcutta High Court and various other trial courts. But that being said, the use of technology till date has not been very friendly. This is a very unfortunate situation, considering the fact that we have witnessed the Supreme Court taking very stringent action. We've seen that in 2005, where various comprehensive dossiers have been made under the aegis of the Supreme Court, with the theory of inclusiveness in the sense that technology must spread across all the regions, must spread across the strata of courts, and will not be discriminated upon whether it's a high court or a lower court or a trial court, etc. That was again reiterated under the aegis of Dr. Chandrachud, who is the present chairman of the committee of the Supreme Court, where he again stressed, apart from the fact that digital courts will be here to stay, apart from that, he has stressed upon the fact that influx of technology is a thing that will happen, and is a thing that we're here to stay. But above all, it must traverse all the courts, including the High Court and the trial courts. So with that being said, on my personal journey, so apart from the in-person hearings that were going on, so some of the last matters which I did so this I'm talking about the week 12th to 16th of March, when the virus was just spreading across across the country. So I had done a few physical hearings. Those were the normal hearings. I had done few in the High Court, few in far off places called the DRT in Navi Mumbai, etc. And it was a very strange sight. There particularly was no sort of precaution at that point of time. There was a judge. However, litigants were crowding the entire area, and the common area leading to the judge, only the counsel and one client or the representative of the client was only allowed to be present before the judge. So that was the region, that was the time just before the lockdown, etc. Few matters were done in the High Court where the panic had just started to come in. Mentioning was not allowed for any urgent matters. Matters were not kept for the week thereafter. And then we were suddenly hit by the pandemic. Now, of course, it's a very difficult time, but thankfully digital court started. So I'll talk on two regions which I'm conversant with. So I'll talk on Maharashtra and I'll talk on West Bengal, which of course will determine the procedures that are undertaken in these two regions is a determinate. You can understand the procedure in the other parts of the world. So in Maharashtra, since I've been doing a lot of corporate matters, etc., so I had a lot of matters coming in before the NCLT. Now, before I touch upon that, I would want to say that technology in law has been an integral part of the system. There has been a gradual influx of technology, and a lot has been said about that. some of the things which I thought worthwhile mentioning today is that in 2017-18, about 1.5 crore pages of civil appeals were digitized for the first time. So right from independence till 2002, entire records were digitized. In fact, in our very Bombay, in our High Court at Bombay, so there are records that are being digitized. All the old records are being slowly digitized. In fact, there are I will not say rumors, but there are information that is being said that there is information said that various old records and those which are disposed of, so those will be destroyed, but after due consideration of converting that into an electronic form. So those are happening. This is because of the fact that keeping a bunch of papers will consume more space than converting that into a small digitized form, which takes an insignificant amount of space. And so those work have always been undertaken. In fact, I'll come on the practicality of it. I remember in my very short span of practice in both these regions, I have seen especially in NCLT. Of course, during the time of my practice, I've already seen that case status orders were all being uploaded online, and the litigants were very happy about it because of the fact that they don't really have to go behind the life of a lawyer just to understand what was the last order, what is the next date, what is the present status, etc. So I consider that to be a giant leap, in the sense that it is finally being for the litigants, and it is causing less headache for the advocates. So, and it is a different issue altogether that most of the litigants are not aware of this very simple procedure that is to be done. However, be that as it may, I have also seen e-filing systems being undertaken by the Bombay High Court, even though I do not know how well a functionality is of that e-filing system, especially of the Bombay High Court. We've also seen during my practice about the filing of court fees online through the Bharat Kosh or the Mahakosh websites, where there are easy procedures. You don't have to stand in line. You don't have to be out in the sun, wait all day, try to know out the nitty-gritties, and then waste your time. I consider time to be the essence of everything, because time is something which you can't buy back. So technology in that sense has been very good, has been very nicely made. However, execution has always been a problem. There are various problems. There are various macroeconomic problems attached to it. I'll come to that. I have also seen in NCLT, we've just been given a very robust e-filing system where everything has to be uploaded online. But of course, a few weeks after that, after the system was in place, because there was an occasional loss of data here and there, or the data was not being able to be procured in time. So the NCLT, especially in Bombay, they were always requesting all the councils or the advocate and records to bring a copy in physical form with the NCLT. Now, I found that very tragically funny. Why? Because you have a system in place, but without duly testing the system for a significant amount of time. We went back to square one, where we were again compelled to file hard copies along with the soft copies, which makes it much costlier. Because one you're scanning, then you are again taking out print, then you're again taking prints of the same copies. So that makes it more costlier. Even in the High Court, so I'll come to the High Court now, is that the High Court started off with hearings on Zoom in some of the platforms in some of the courts. However, we switched on to WebEx. With regards to the filing, we still are in a form where we are made to file all the petitions, applications, precipi, undertaking, all the documents necessary for the hearing of your matter online. They have come out with very substantive notifications, very easy to read, easy to understand, simplified instructions as to the mode of filing, which is corresponding to the bench that will be taking that particular kind of matters. And accordingly, there were email IDs that were given on single bench, division bench, appellate side, etc., criminal side, bail matters separately. So this previously, I'm talking about till the month of June. We were made to just simply convert all our petitions into PDF form, keeping the format as per the formats given by the Bombay High Court. Keeping that same, we were made to only convert it into PDFs and send it across to the concerned email IDs. And they used to be reverts and the precipi, of course, the urgency precipi, where they will consider the statements made by you on your precipi, and on the basis of which they will try to allot your matter. Now, howsoever, since last 2 weeks, again, we are again made to first file it online, get an acknowledgement, then get a token number for you to again file it offline. So you have to go to the High Court and file a physical copy of the petition that you are intending to file. So really, I mean, and this is how it's going on. So we are using Cisco WebEx. In NCLT, we are still using video, VIDYO, and so a very intriguing thing which I really want to share, and which is a very good thing which I experienced, is that whilst on my hearing before a bench of the National Company Law Tribunal in Mumbai. So procedure is that you have to give them all soft copies. You don't need to go to the tribunal to file your hard copies. So that was exempted. So we were filing all soft copies and they were taking pending matters. So this was a case of restoration of a company which was struck off by the Registrar of Companies. And they had very carefully detailed down the entire cause list, a handmade cause list, along with the previous dates, etc. But a very intriguing fact is that the manner in which the argument went forth, it was very apparent that the files were not placed before the bench, or maybe it was placed. We don't know. But the matters were getting disposed of solely on what was being argued or what was being stated by the counsels. So the point which I want to make is that a lot of reliance was kept on what was argued by the counsels or the advocates. That means that ethics and morality and your professional ethics towards your profession, towards the bench, has raised significantly. And this I say because in the digital world, we are still trying to experiment. The judges are still trying to experiment. It is all a very new experience for all of us. And in this realm, it is very difficult. I can completely understand from a judge's point of view when you have the petitioners, you have a petition which is going to about hundreds of pages. You have a reply, you have a rejoinder. Thankfully, they are not accepting any rejoinders. But by that time, the pleadings are complete. You have already reached a humongous amount. And this I've seen in one of the matters where I think it was filed by ONGC in some of the bid matters. I know that for a fact because that hearing was going on just before my case was being called out. So it was, the judge said across the bar, it was said that it is very difficult for us to understand because finally everything is digital. And how many systems do we keep in front of us if we are not accustomed to this kind of a practice? I am pretty sure that in the due course of time, we will adapt to it because this entire digital practice, we've not been given a choice. So that is number one. And for the continuance of a practice, from a practitioner's point of view, and for the continuance of the of of this entire justice system in India, we have to continue with this digital hearings one way or the other. The Supreme Court has also stated, I was just seeing a media briefing, one of the newsletters said that the Supreme Court has indeed said, and which is a fact in all logical sense, that digital courts, for number one, it is here to stay. And number two, there could be a mixture in the due course of time, mixture of both digital and physical courts. And I keep saying this, that there could be certain matters which can be disposed of only on the basis of certain parameters. Just like in Companies Act, what I can think of the top of my head, the disposal of restoration matters, that is cases filed under Section 252 of the Companies Act 2013. So those matters can, of course, be disposed of on the filling up of maybe a form, much like what IBC is. So in fact, in other CPC provisions, or in other, let's say, in accident cases, or in cases where there are established principles of law, and which are prima facie can be determined, can be disposed of, those indeed can be disposed of in digital hearings. Of course, it will be tough. It is a fact which remains to be seen, tried and tested, how it can be done. Again, in all practicality, I would also want to come to the lower courts, because I'm most concerned about the lower courts. High courts have a system in place. There are advocates who are appearing before the courts. Even I am appearing before the courts. But I think the most troublesome area of this entire digitization, I think, is with the trial courts. I will term that as the lower courts. The trial courts, or the lower courts, or the commissions, or the far off places where there are courts and tribunals, and young lawyers who maybe just come into practice, or maybe do not have that kind of system in place, or maybe where there are extreme network connectivity issues, just like the case of my partner who's staying in Ambernath, which has a lot of network issues, even though she's an extremely talented advocate and counsel, but her legs are cut off. She does not have any connection. So even if there is a matter which she wants to move, she's unable to move. Her clients are unable to come to her. She's unable to give justice to that practice. So what happens then? I've also been made to understand that the Bar Council of India has moved some kind of writ petition in a desperate attempt to aid and assist monetarily or otherwise junior advocates or advocates who are facing an extreme heat in terms of money. That I think has been filed with the Supreme Court. I'm not very sure about that. But I think these are the two areas which are troublesome. I am appearing before the trial courts. I had a matter which was allegedly of an urgent nature. Howsoever, so this was in a court in Malad, in Dindoshi. It was a city civil court, and there are in-person hearings happening over there, and it is a sight to see. You can see the honorable judge sitting behind two sheets of plastic, those transparent plastic, and you have the entire court staff in full gear. You have the gloves, you have the mask, you have the entire deal, and it's very difficult. I mean to say it's very challenging to argue, for an advocate to argue with that mask on. So one, you're sweating. Second of all, your mask is preventing you to put the entire thrust of your argument to the judge. And it seems like you're mumbling something, and then there are two sheets of plastic, and then the judge is also behind mask, the entire deal. And then you say something, the judge says something, and the client hears something else, and something else is done. So really, it was very fun for me to watch. In fact, I did inquire. So whenever I go to any court, I do inquire what is the status, COVID-19 status in any court. So I was told that there were cases of court staff, and those floors were sealed off about a month and a half back, and I had to travel through those floors to get to the judges, to get to the courtroom, and it is extremely scary, to say the least. But then I always had a choice of not to go. The client did not have a choice, but I did go there. But for advocates and for even for judges, where I don't think there is any explicit notification saying that you please do not conduct hearings. I think it is only on the basis of what is the COVID-19 status of your court. So in the absence of these kind of notification, the judges are bound to sit. They are sitting only in extremely urgent cases. And I don't think there is any digital hearings going on, at least in Mumbai. In Calcutta, yes, there is a court called Alipur Court. It's a sessions court. In the sessions court in Calcutta, proper Calcutta, the litigants are given a choice of using a platform of their own. So they've given only two choices. One is of Google Teams, Microsoft Teams, and the other is of Skype. So these are the two options that were given. But again, we are coming back to the age-old problem, the macroeconomic problem, as I fondly say it. Advocates, major advocates, especially the trial court ones, are not economically well off to have the kind of systems which I'm using currently, where we are surrounded by systems, we are surrounded by seamless internet activity. We've got that the full thrust of technology aiding the endeavors of both our practice and the litigants that we have. But I think it is really unfair and unfortunate that this kind of technological luxury is unable or is not being reached upon a majority of advocates in the lower courts, in the trial courts. I know that for a fact because I come from a region which is not really as well off as the city of Mumbai, even though I really feel that in times it will be. And I've got a lot of friends, a lot of associates, affiliates who are really struggling in far off areas. Those are district courts, those are sessions courts. But this COVID-19 era has suddenly pushed into such a realm, an unpredictable, unimaginable realm, especially in the lower courts, which I think is getting the most heat out of this entire era, entire pandemic era. So yeah, coming back to the Supreme Court's dictum on and the motto of digitization in the COVID-19 era, inclusiveness, yes, should be the number one priority. The high courts are, of course, the privileged ones. The Supreme Court, of course, apex court, can't say anything. But I think lower courts should also be included in the ring of privileges. As recent as last week, I got to hear that the small causes court was cordoned off because of COVID-19 era, and unfortunately, there are no hearings of any form that is going on over there. Before going into the next tranche of what I want to say in all practicality, I want to talk about a case which I did about 2 years back.
Rajdeep, sorry to cut you short. We have like 7 minutes left. So if you could brief that, and then if we can take Q&A.
In 2 minutes, I'll brief that.
Okay.
In 2 minutes, I'll brief that.
Okay, sure.
Basically, so that case was a divorce by mutual consent, and my client, I was for the wife. The wife was staying in United States of America, and there could be no possible way where she could come. So I really looked. So there was a precedent set by our Bombay High Court saying that in case of certain parameters, if the wife cannot come in a mutual divorce matter, it can be waived off, and it can be done through video conferencing or through a power of attorney holder, and the video conferencing can be done for the final consent for the second motion to be moved to video conferencing. So this was done in Thane Court. Oh my God, I moved heaven and earth for that to be admitted without going to the High Court. But that was done, and that was, I think, a precedence of sorts set in the Thane Court, where something like this was done for the first time, even though there was a precedence set by the Bombay High Court. So all in all, I have been very technology friendly, even though I do not really know how to use some of the applications, but I always am fond of technology. I'm fond of technology in a sense that it gives me wider reach, give me wider capacity, It enhances my capacity to work more, get more clients, and help the justice system. And so this is my practical take on litigation in digital era.
Thank you, Rajdeep. If anyone has any questions.
I have one. I'm Vedang Deshpande. So, sir, as we know that Indian judiciary, it lacks in speedy justice delivery. So now thinking about post-COVID era, do you think digital platforms for courts would be still in use in order to administer justice for a quicker delivery of justice, and also the use of courts in the other ways?
So correct. So we are in technology right now, and technology for now is helping you to continue litigation. That is number one. Number two, when the physical courts finally start, if at all, when the physical courts finally start, if at all, technology will, if not a greater role, but will have a different role, but will definitely have a role to play, in the sense that for now technology is being used, as I said, for the continuance of this entire justice system, so that there is not a complete collapse of the justice system. That is the why technology has come in its place. So when the physical courts start, it will not be a complete abandonment of technology. No. Justice Chandrachud has specifically stated, and I think the Supreme Court committee has also stated, that technology, digital courts are here to stay, and maybe there will be a mixture of both digital and physical courts. So perhaps, as I said, there could be certain courts, certain dedicated courts, and for only meant for certain dedicated matters, which will only happen digitally. It could be entirely possible that we have day and night courts too, and night courts could be done digitally. That answers your question.
Thank you, sir.
Any more? So, if there isn't anybody, I would like to ask one. So, Rajdeep, what would you advise law students on how to prepare themselves for a digital future?
Okay, so I believe in my heart that law students are more digital friendly than advocates of when I passed out. Because when I passed out, we hardly had those Moto Razor mobiles where we just learned, okay, these are what are smartphones? We were just learning. And now we're at an era where we are now say that we are conversant. Law students who are passing right now, they already have uh, the knowledge, the apt knowledge of various databases. We sometimes still use the books, the various journals to find out cases, because we feel that going old school is more in vogue. But for law students, it is SCC, it is Manupatra, it is India Kanon, it is Google, which I think, in the sense that it enhances the power of research. And I think research is the backbone for anything that you do, precedent set. And so I think law students, in all sense, they are more capable than what we were. Only thing that they need to realize is that the full potency of using the digital courts. They just need to understand the full potency of it, and I think they'll be fine. It is we who should be looked after.
Sure. Anybody else? Because we're like time bound. We have like 2 minutes left.
Sir, ma'am.
Yeah.
Yeah, sir, I would like to ask, like, during these e-courts and all, how evidences and witnesses can be produced?
I knew that was coming. So it's a very difficult task to say right now, because there are various nitty-gritties that are involved on confronting and witness, confronting a document, because everything is done digitally. So an Evidence Act really provides for digital documents, but it really does not provide where even the digital documents is being provided digitally. So there are arbitrations that are happening, and so prima facie everything is done on the face of it, and there are various undertakings, and everything is being done through an affidavit. Remember the fact that all petitions that are filed in the Bombay High Court, the Bombay High Court has stated that all depositions, all notaries, and all affirmations are being exempted. And there is an undertaking taken by the judge saying that all what you're saying is taken at the face value of it. If found guilty, the advocate and the client will be facing the competent provision.
Uh,
So it's a very difficult.
Sorry,
It's a very
just in case, why don't we continue once you finish, because there's less than a minute left. You all can all relog onto the same link, and then we can continue the Q&A.
I think we can do now. So then I'll continue. Let's relog in.
All right.